Здравейте! Добре дошли на този разговор на Европейския съвет за външна политика. I'm going to switch to English because we have as our guest Piotr Buras, who is head of the ECFR office in Warsaw, but also Daniel Smilov, here from Sofia, from the Center for Liberal Strategies. And today we're going to talk about the rule of law, which for many is a bit of a concept rather than a reality. So what we will try to do is to bridge the concept and explain how it can change also the life of citizens. We're very grateful to the Konrad Adenauer Stiftung for their support for this conversation today. And without further ado, I will immediately ask the first question. Rule of law, especially here in Bulgaria, has been also an issue in the electoral campaigns. It has been a dividing line domestically. But how is it seen from Europe? It seems to many that Europeans don't really pay attention to the rule of law, that they care about stability, and that as soon as somebody delivers them this stability, this is good enough to kind of close one eye on the rule of law.
Bulgaria is an interesting case from the perspective of the rule of law. It's not as prominent as Hungary and Poland. So when issues about the rule of law come to mind, the first countries are normally Hungary, lately Poland. Bulgaria, not so much. And the first question is why? And my answer to that is that while in Poland and Hungary we have outright open opposition on behalf of the governments to interpretations of the rule of law coming from Brussels. In Bulgaria, this is not so. Actually, Bulgarian politicians, they take a little bit more Byzantine approach, and they agree formally to everything that comes from Brussels in terms of recommendations and so on. But actually, they bend the rules here. And in fact, we have a lot of informality, which has developed into clientelistic and corrupt practices. And in fact, we have this mismatch between normative commitments and realities on the ground. So that's the Bulgarian case, and I believe it's different from what we have in Poland and Hungary. It's also a difficult situation, but politically it is, I wouldn't say more acceptable from Brussels' perspective, but it lacks the urgency that the Polish and the Hungarian case create. In our case, we don't have a court which openly opposes, for instance, EU law or challenges the supremacy of EU law and stuff like that. But despite this conformity, formal conformity, actually, when it comes to informality, clientelism, and so on, the real picture gets quite twisted. And because of that, even in Brussels, in Strasbourg, there is this understanding that Bulgaria has deep structural problems with the rule of law, especially in the area of the fight against corruption.
We may not have a court that over-interprets national law, but we have a prosecution that under-interprets its duties, it seems.
We have a prosecutorial office that appears to be selective. Actually, it's quite active regarding particular cases and very inactive regarding other political actors. And this is not a problem of interpretation of the rule of law. It's a kind of an application problem. And From that perspective, the Bulgarian case might be easier because it doesn't raise conceptual issues. It is a question of application, but Bulgarian politicians have become very skillful in presenting the appearance that they're doing something, while actually quite often nothing substantive changes.
So Piotr, when you listen to this, you probably think it's different, but yet there is some sort of a Central European malaise.
Yes, and I think Denis said that the Bulgarian case might be easier, but I think in a way it's perhaps it is even more difficult than the Polish or Hungarian case, because the problem is there, but it's much more difficult to address it. Because there is no, if this is the case, that there are formal appearances of compliance with the rule of law, but in fact the problems are substantial and structural, then it is a problem for the EU and for its institutions. Why is the rule of law so important for the European Union? Because the EU is actually a set of rules, nothing more than that. The EU is law-based in the sense that it doesn't exist without these rules being followed by the EU member states and institutions. And the EU does not have an army, does not have a police, does not have a power to ensure that its law is implemented. And this is the job for the EU member states and their institutions. So when a EU government says, I don't want to implement the EU rules or the EU legislation, or I don't want to respect what we have agreed upon, the EU doesn't have any means, any instruments to enforce it. So that's why the situation now is so dramatic. And I'm coming to Poland because we have a first time basically it happened in Poland that the government basically introduced a system of judiciary which in an absolutely outright way violates the principle of judicial independence. So the judges are nominated in a way which is outrageous because the process is controlled by the politicians. And if you look at the key institutions which are now responsible for protecting the judicial independence, they're doing just the opposite. So basically they are restraining the judicial independence. And this is a systematic issue. And what happened? The European Commission and the European Court of Justice said it is not in line with the Article 19 of the EU Treaty, which basically obliges the EU member states to ensure that the rule of law, judicial independence is protected in the EU member states, because free courts are the essence of the EU system and the foundation of the EU system. And the Polish government said, we don't care. We don't believe that the European Commission and the Court of Justice of the European Union have the power, have the right to intervene into these affairs, because judicial issues are matters of national competence. But the EU institutions and many EU member states, and this is very important, also member states say, but how come? I mean, we have our rules, we have principles enshrined in the EU treaties, but most importantly, we need to have an arbiter, we need to have an institution which can assess whether these fundamental principles without which the EU cannot exist are respected or not. And because if you run it to the extreme and we say the EU institutions have nothing to say when it comes to the judicial systems in the EU member states, then the conclusion could be, for example, I'm not a lawyer, but if the Polish Prime Minister said they want me to be the president of the highest court in Poland, the EU Commission could not say anything, because this is national competence. It's absurd. I mean, it cannot, this is not how the EU can work. And then we have in Poland a politically controlled constitutional tribunal, which issued a verdict last year that basically forbids the Polish institutions to follow, to implement the judgments of the highest European court regarding judiciary matters. So we have a massive conflict between not just between judiciaries or judicial institutions, but between the Polish government and the EU institutions, including those intergovernmental institutions like the EU Council, on how to basically interpret the EU law and to what extent the EU member states can have full autonomy when it comes to designing not just the system of judiciary, but also defining whether the judges should be independent or not. And this is, I think, a fundamental issue for the EU and for its future, because otherwise,
But rule of law is not only about courts and judges and prosecutors, it's also about government practices, it's also about corruption, it's also about media control. And it seems to me that maybe Hungary is the place where all of those aspects are visible. And this is maybe why Hungary also stands out so much.
Yes, I think there are two things which need to be said. I think about Hungary. The one is that the Hungary started this process much earlier than Poland, already 2010 or even earlier, and it's the process of demolition, basically the rule of law system, and this is it simply was a time where the Commission did not have the courage to intervene,
right,
and did not have was kind of overruled by the developments. So the whole process of rule of law protection in the way how we know it now started with Poland 7 years later. But the other thing about Hungary is that Hungary did it in a much more clever way. For example, the Hungarian government did not breach its own constitution, but it changed the constitution so that these kind of unlawful or what looks like unlawful was actually in line with the constitution, and was, I think, much more skillful in managing this conflict with the institutions for a very long time, until it's escalated also 2 years ago. And now both countries are under supervision of the EU and have problems when it comes to the release of the EU money, when it comes to EU procedures to protect the rule of law. But I think when it comes to the democratic backsliding, or actually the introduction of a semi-authoritarian regime, this is how we should frame it. Overall, Hungary is more advanced than any other country.
Is the leader, yes. So we're mentioning Orban here in the Bulgarian context quite a lot. What do you think are the similarities? And still, I'm keeping in mind this perspective of stability versus justice.
Well, the similarities are in the results, but the differences are in the way that this result is achieved. And Piotr said already that the Hungarians did it politically, openly, through constitutional revision. So Orban had this massive constitutional majority, changed the constitution, and introduced new rules of the game, which allowed for massive political input in the judiciary. In Bulgaria, the result is pretty much the same. So basically, we had a government which stayed in office for more than 10 years. This was GERB's government. Boyko Borisov had 3 types of governments with different coalitions, but generally GERB, together with some partners, they were ruling for more than 10 years. And this stay in office gave them the opportunity actually to transform the system without constitutional revision. Separation of powers works, but it doesn't work when you have concentration of power over a long period of time, because it relies on different checks and balances and so on. And when a single party or a coalition of parties stay in office, win elections for 3, 4, 5 years, there is this danger that the constitutional model is being held. It's well, the institutions are there, but the substance is no longer there. And this happens if you have politicians that have not internalized separation of powers values and rule of law values, but they try to maximize the profit for their own party by using the system. And after a while, even without a constitutional amendment, a constitutional change, it could be possible that key independent bodies are one by one taken over by the same political formations. And this is the Bulgarian case. So the worry of many is that we have a very powerful prosecutor general who is actually close to this constellation of power, that he is very favorably inclined towards them, and in fact just the opposite towards their opponents. And this is possible through this long staying power of the politicians, and also because of their unwillingness to take seriously rule of law values, just to play with them for their own benefit. And what the European Union can do in this case is to raise red flags. In the Bulgarian case, we have a huge selection of red flags coming from various institutions. So we had the cooperation and verification mechanism, which somehow ended without actually really being ended. But immediately we entered other monitoring mechanisms and different types of law conditionality. And from time to time, there are kind of quite clear signs from the European Union what should be done. For instance, one problem which Bulgaria hasn't dealt with is the fact that the prosecutor general in our case has to authorize proceedings against himself. And that's ridiculous because it is a violation of basic rule of law principles, but we cannot deal with that successfully for more than 30 years now. And there have been successful warnings and direct instructions, the latest one coming from an opinion from the Venice Commission how to deal with this complex problem. So now, in the context of the recovery and resilience plan, finally this issue might be resolved because it is a condition for Bulgaria to get the money from this plan. But the resistance of the system is quite indicative of the structural depth of the problems that the country faces.
The Commission decided to make this funds rule of law relation very direct. And they did it through the Resilience and Recovery Plan, which says that unless the respective member state fulfills the rule of law reforms, it is not going to have access to those funds, which are quite big amounts. In the case of all the countries we have been discussing, of Poland, of Bulgaria, and of Hungary. How does it work in the Polish case? It would be interesting. What will happen with the Hungarian plan? If you can maybe explain that a little bit. And what is your prognosis?
Yes, I think this is very interesting because it happened almost accidentally. that the Commission suddenly got this kind of leverage, kind of instrument into its hands to deal with the rule of law violations in the EU. Because this Recovery and Resilience Fund, this 750 billion euro fund, was set up 2 years ago as a response to the COVID-19 pandemic, and it has a very indirect rule of law conditionality. In the Polish case, this is the reason why we have at the moment serious problems with the release of the Polish money. The reason for that is that Poland does not comply with some recommendations received from the European Commission under the yearly European semester. This is a yearly review of reforms in the EU member states, which the Commission does every year, and it issues for each country some recommendations. And in Poland, for several years in a row, there was a recommendation to improve the standards of judicial independence. That's one of the 4 recommendations Poland received 2020 and 2021 and even before. And then, according to the regulation on this recovery fund, the Commission can expect or require from the EU member states to comply with all recommendations which had been given to them as a precondition for the release of the money. So the Commission said, look, you haven't complied with the recommendation to improve the judicial independence. You haven't improved the judicial independence, just an opposite. The standards of judicial independence in Poland worsened because you don't implement the judgments of the highest European court, the Court of Justice of the European Union. So unless you comply with this requirement of improving the judicial independence, you won't get the money. And this is where we are now. There are some concrete requirements which have been defined in the Polish National Recovery Plan. So this is the plan which defines the reforms, the investments which Poland intends to carry out in the upcoming years thanks to this EU money. And there are clear requirements, clear conditions, which also the Polish government agreed upon together with the Commission. They agreed, okay, we will remove the disciplinary chamber of the Supreme Court because this chamber does not comply with the EU standards. We will do this and that. There are 3 main points. And now we are in the process of implementation of these, as we call them, milestones. So these are milestones which need to be fulfilled before the money can be released. And the Polish government says, we have already introduced or adopted a reform, a judicial reform, which is meant to fulfill these milestones. The Commission said, no, this is not enough. You don't actually comply with what we meant as a precondition for the release of the money, so the money is not coming. And this process drags on. The time is flying. This money needs to be, this is important, needs to be spent within a couple of years until the end of 2026. The whole process needs to be finalized, and these are complicated investments. So if we start these investments in a year, then we will not be able to finish them. So basically, we won't start them. So now the problem is that the government is coming very much more and more under pressure to comply with these requirements. But the coalition which forms the government cannot come to an agreement among themselves if and how to do it, because there is a party of the not by accident Minister of Justice who is in control of the whole system of judiciary and prosecution, which is opposing any compromise with Brussels. And so it's very difficult to predict if and when a compromise can be struck, because
And how about the Hungarian case?
And Hungary is even behind Poland when it comes to the process of the release of the money, because Hungary has not even signed this national recovery plan. So they don't even know formally what they need to do in order to get the money released. So because this will be enshrined in the national recovery plan, but now there are very intense negotiations going on because this national recovery plan of Hungary needs to be finalized until the end of the year.
Yeah.
Because if it doesn't happen, Hungary will lose the money
altogether. Yeah.
So they need to do something, but so I would expect that they will agree with the Commission on the national recovery plans. But this would only mean that the Hungarian government will commit to do something.
Yeah.
They will commit to introduce reforms of judiciary or prosecution, especially anti-corruption mechanism, which once carried out, will allow the Commission to release the money, but only upon this condition that Hungary will indeed deliver on these commitments.
Yeah.
But we are not yet there.
One last point. When we talk about funds and about rule of law, it is obviously not the entire story, because the EU is developing and the levels of integration in the EU are becoming more and more. And so depending on how many levels of integration a country participates in, the more its voice is heard, right? So if you do not participate in kind of the outer circles, then you have very little, or you have not the word, you don't have a say on many issues. In the Bulgarian case, this whole idea about justice, anti-corruption, rule of law has also other implications in terms of its integration.
Mm-hmm. Yeah, well, first, one point about the difference, again, between the Bulgarian case and the Central European. We do have the National Recovery Plan. We have said to Brussels, yes, we're going to fulfill all these conditions. But now the question is about implementation. Mm-hmm. So first, we don't have a stable parliamentary majority to carry out the necessary reforms which have been promised. And secondly, once we come to the details, there will be different lobbies trying to interpret again all these conditions in a way which is the most favorable to them. And it will be, it might be not a surprise if at the end of the day, even after certain reforms are carried out, that we'll see that nothing dramatically has changed. So this is the danger in the Bulgarian case. And so what should be monitored is not only the official formal agreement that is given, but also the details of the implementation. And secondly, Bulgaria has serious ambitions to join the Eurozone and also to become a member of the Schengen area. Together with Romania, we are still outside the Schengen area. And the rule of law issue is a condition for these two as well. So it might be not... in the Schengen case, it's a kind of outright and openly stated. In the Eurozone is maybe not the most important criterion, but again, it will be something that will affect the decision of others when the issue comes in a couple of years, even sooner, hopefully. From this perspective, Bulgaria really has an interest to solve those problems, and maybe because of that, at least formally, most of the political players declare willingness to comply with conditions that come from Brussels and so on. But again, I would say that the interesting part will be in the implementation and the interpretation of different technical, from a certain perspective, elements, but elements that might raise principal issues as well.
Thank you very much. I think this summarized our conversation very well. I hope it was interesting for you as well. Thanks a lot for watching. On behalf of ECFR and my guests, Daniel Smilov and Piotr Buras, it's goodbye.
Фондация Конрад Аденауер е германска политическа фондация, изповядваща християн-демократическите ценности. Тя работи от 65 години за мир, либерална демокрация, правова държава, правата на човека и социално пазарно стопанство. Седалището и академията на фондацията се намират в Берлин. Освен това, тя присъства с образователни форуми в 18 германски града. В Германия тя има 560 сътрудници. Фондация Конрад Аденауер има също така дългогодишен международен опит. Тя работи в 120 страни и има 107 бюра в чужбина на всички континенти с общо 737 сътрудници. Фондацията открива бюрото в България през 1994 година и от тогава е осъществила многобройни проекти с партньори в страната. В момента бюрото се ръководи от Торстен Гайслер, който казва: "С нашите български партньори и приятели ни свързват дълго и основано на взаимно доверие сътрудничество. Заедно работим за укрепване на сътрудничеството в рамките на Европейския съюз и НАТО, за западните ценности, върху които са изградени тези два съюза. Свободата, демокрацията и правовата държава са ориентир за нашите действия и в България. Ние с удоволствие работим в тази страна, която е постигнала толкова много след промяната през 1989 година."